and the penal code used in northern Nigeria refer to the word offense. That is by our statutes. But your right to seek your hand stops at the nostril of another person. So anything that you do that is against the law and there are penal cases, is a crime. Anything that you do against the law that have the consequences of either paying fine or imprisonment is a crime. It should be noted that criminal code and penal code as applicable in the southern and northern Nigeria are the oldest legislation of prohibition of crime in Nigeria and are in existence in this. These laws entered amendment and enactments. In Kwara State, the applicable penal law is called the Penal Code, which we inherited from the defunct government of Northern Region. The origin of our penal code can be traced to the Southern Asian countries of India and Pakistan, and which Northern African country of Sudan. Penal code was officially adopted by the government of the then Northern Region, now Northern Nigeria, in the 50s. I refer you to the Robinson Law, which is the note of penal code. With the creation of state in 1967, penal code law became applicable and enforceable in Kwara State for prohibition and punishment of crime. The most recent legislation of the penal code in Kwara State is contained in Part 4, laws of most of us will know this law, because there is no way you talk about the principle of Nigeria and no nation is authority. Where it says that an act is a crime, no act is a crime unless it is defined and punishable, and the punishment prescribed by written law. Section 36, sub 12 of the Constitution of the Federal Republic of Nigeria, 1999 as amended, provides that no person shall be convicted of a criminal offense unless that offense is defined and penalty prescribed in the written law. In Georgia, we have a great Federal Republic of Nigeria, the Supreme Court said that an accused cannot be punished for any offense unless the offense is defined and the penalty thereof is prescribed in the written law. And the written law must be an act of the National Assembly or law of the State's Assembly or any subsidiary legislation. It stands for the above that for a person to be punished under the law, there must be a written proscribed alleged wrong, and that there are penal consequences if the alleged offender is found guilty of. Therefore, the concept of guilt and crime means the involvement of your person in criminal act and the legal framework governing criminal responsibility over acts, culpability, conviction, punishment, and possible reformation of the convicted young offender. The two essential elements or components for most of crime, as we were taught in our 300 level, led by Professor independent license, taught us criminal law policy, are actors where without the victim's mind and menstrual. The actor is the guilty act and menstrual is the guilty mind. These two components of most of crimes require that there must be a voluntary physical act of omission, which is relevant, and combined with a culpable mental state, which is the mainstream, like intent, knowledge, or recklessness. In Ilorin against Federal Republic of Nigeria, the Supreme Court said menstrual is an act, is a necessary ingredient of an offense. Menstrual is the criminal intent or guilty mind of the accused. Menstrual entails that there will be a meeting of the mind and the act of the offender for the offense to be perpetrated. Given that, there is no way humanly possible to ascertain with mathematical accuracy and device of a man's heart. The intention can be discerned from the action of the offender and other circumstantial evidence. In this case, the action of the appellant shows his guilty intention. in the case of Ilorin Massachusetts. It is worthy of note therefore that there are exceptions to the aforementioned general rules in some strict liability offences, like unlawful possession of human parts, prohibited drugs, firearms, and so on. See section 3.1, whereby special provisions can have in there loss of condition in Nigeria, and addition of the Supreme Court on the case of state obligation of professional in those states. The essence of this is that in some cases, as I've earlier told you, that there must be actors real and menstrual. In some cases, the issue of your intention, the menstrual, will strictly not be considered. As I discussed in the next paragraph, a good example is a student in possession of firearms or being found in possession of India hemp, marijuana, and some other things. These are strict liability offenses. Nobody will ask you the menstrual. Nobody will now label the prosecution to prove menstrual as one of the ingredients of the offense. Once you are found in possession of this prohibited item, it is a strict liability offense. So it is not a justification for a person found or a student found in possession of a firearm that they go to not say I'm using it for hunting or I'm using it for protection of myself. These are strict liability offense. What the prosecution needs to prove in the case of illegal possession of firearm is that you are found in possession of it and nothing more. So what you then using it for is not required. Therefore, it's very important for students. Any student found in possession of firearm is strictly liable, or anybody found in possession of marijuana or Indian. It is irrelevant for you, a person like a female student found in possession of Indian hemp, to master and using it for the growth of my hair. So the Igbo-Ladi or Igbo-Lodi or among us, we take note that if you are found in possession of this prohibited item, it's a strict liability offense. And nothing, there's no burden on the prosecution to prove your intention of whatever you want to use it for. It's a strict liability offense, and this should be taken note of. Thank you. Therefore, it is not an excuse known to the law that the student found with a gun or any leather weapon is in possession of sale or protection, as earlier as said. Also, it does not concern the law that a youth or a student in possession or uses India hemp to grow his or her hair or smoke it to gain other hours in reading, and so on. Possession of these classified items are strictly prohibited, and so one can only come in contact with these weapons or drugs through the due process of law, like obtaining license or kind of allegations or doctor prescriptions for the use of these drugs. Due to government inquiry, criminal activities in Nigeria has received a worrisome dimension in the recent times. This poses a great threat to the peace, security, and harmony of Nigerian society. My experience in prosecution and interaction with the youth, with the young people, reveal that a lot of young offenders gradually move from commission of minor offences, like stealing of some pieces of meat from the cooking pot of their parents or roommate as applicable, to robbing their fellow students of their ancestors, to more serious offences like courtesy, rape, drug trafficking, armed robbery, and so on. In view of their goal, once the prosecution has successfully discharged the evidential burden of proof and establish of all the ingredients of the alleged offense against the defendant beyond reasonable doubt, such a defendant is liable to be found guilty, irrespective of the ministry. Convicted and sentenced by the trial court authority. In Demo against COP, the Supreme Court has recorded as standard of proof of crimes and meaning of proof beyond reasonable doubt evidence. In a criminal trial, before the sanction punishment can be applied, the law requires that incident of the offense or of each of the offenses must be proved by the prosecution throughout beyond reasonable doubt. In other words, in all our criminal cases, without exception, the prosecution has the responsibility To prove the offense preferred against the accused person beyond reasonable doubt. The concept of this mode of proof, i.e. the proof beyond reasonable doubt, in simple and ordinary parlance means that the prosecution is required by the law to prove that both in law and fact the accused person committed the offense or offenses with which he is charged. I'm likely to know that there is a difference between the concept of proof beyond reasonable doubt and proof beyond all shadow of doubt. Proof beyond reasonable doubt is just for the prosecution to prove the item, I will discuss this later in this presentation, to prove the essential evidence of the alleged offense. Anything, any burden of proof placed on the prosecution beyond this is required to prove beyond all shadow of doubt. Administration of criminal justice. Some legal minds believe that administration of criminal justice is peculiar to court rule alone and criminal procedure. No. Administration of criminal justice comprises of the institution, procedures, and processes which are responsible for crime prevention, detection, investigation, prosecution, adjudication, punishment, and possible rehabilitation. In Nigeria, these institutions include the police and other law enforcement agencies, public and private legal practitioners, judiciary, correctional service, and other allied agencies. These institutions are expected to collectively function cohesively to ensure justice, deterrence, rehabilitation, and social integration. Unfortunately, the systemic weaknesses have limited their effectiveness for the running of the aforementioned legal concept are the Administration of Criminal Justice Act, which is a federal legislation that was passed by the Act of the National Assembly in the year 2015, and the Administration of Criminal Justice Law of various states. In foreign states, the aforementioned federal legislation was domesticated in 2018 with the assent of the then Governor of Kwara State, Dr. Abdul Fattah Ahmed, in December 2018, and the Administration of Criminal Justice Law 2018. The 50 chapters and 490 sections legal instrument is our encyclopedia of criminal procedure in Kwara State. It is a departure and improvement from the default criminal procedure code, which was inherited from the government. Before the domestication of ACJ of 2018, state prosecutors referred to several legal instruments for the institution and prosecution of criminal cases at the High Court. This includes follow the criminal procedure code, statement made to the police officers' rules, and application for leave to provide a charge in the High Court rules, can see to 5 years of character, and so on. As earlier stated, the criminal procedure code was inherited from the Northern Region and the major procedural legislation and rules for the purpose of criminal cases in all courts in Kwara State. While the statement made to the police officer is a sub-legislation that should pretend the process of reading and recording of the extrajudicial statement of the defendant and the police station during the investigation of the arrest. This rule is most applicable during the trial of the trial before the advent of the criminal of ACJ in 2018. Furthermore, the application for leave to provide a charge in the High Court rules, can see 28 laws of paragraph, is another pre-2018 criminal procedure legislation in Kwara State, which made it mandatory for the state prosecutors to seek leave of the chief judge or the high court judge through ex parte application before criminal charge can be prepared against accused persons at the high court. The advantages of the passage of ACDL 2018 are that all the above mentioned legislation are now incorporated into a single document with modifications. It is the argument of the legal scholar that the application to prepare charge with the High Court, which is mandatory, which may be mandatory for the Attorney General of the State Council to seek permission of the court before a criminal charge can be preferred by the High Court, such as the constitutional guarantee powers of the Attorney General of the State to institute, take over, continue, or discontinue all criminal laws, as stated under Section 211 of the Constitution of Kenya. Therefore, with the domestication of ACJL 2015, so it's ACJL 2018 in Kwara State, this law has gone into extinction. The uniqueness of ACJL 2018 can be seen from the criminal chapter of part, particularly Section 1 of the ACJL states the purpose and objective of the law as follows. The purpose of this law is to ensure that the system of administration of criminal justice in Kwara State promotes efficient management of criminal justice institutions, speedy dispensation of justice, protection of the society from crime, and protection of the right and interests of the suspect, the defendant, and the victim. Because law enforcement agencies and other authority or person involved in the criminal justice administration shall ensure compliance with the provision of this law for the realization of its purposes. The challenges of the administration of criminal justice in Nigeria is general, and Kwara State in particular will be significantly improved with effective implementation of the provision of this law from the period of detection of crime, investigation, prosecution, conviction, sentencing, and correction. The preliminary provisions of the administration of criminal justice for 2018 clearly suggest that the purpose of this law is not only in the interest of the suspect or the defendant, nor the victim alone, but also in the interest of the state as well. This is in line with the vision of Paul Kuta, as a blessed in the case of Josiah against us, when he said, justice is not a one-way traffic. It is not justice for the appellant alone. Justice is not even a two-way traffic. It is really a three-way traffic. Justice for the appellant accused of the erroneous crime of murder. Justice for the victim, the murdered man, the deceased, whose blood is crying to end for vengeance. And finally, justice for the society at large, the society whose social norms and values have been dissipated and broken by the criminal act of appealing them. The Travis concept of justice is what I call the tripartite justice. The tripartite concept of justice. That is, it's not only justice to person alleged of the crime. It's not justice to the alleged criminal, the alleged offender. Also, we need to consider the justice for the victim of the alleged offense. Victims whose rights have been abused, victims who have suffered the act, the alleged act, and also the victim to the society, victim to all of us, who we all agree that this act shall not be done, and someone did it and dissipate the ultimate justice. According to one of the foremost prosecutors in the country, wrote in the conversation in one of the papers, in his paper presented during the recently concluded workshop on administration of criminal justice, he said that I quote, in an ideal society, it is the responsibility of investigators to meticulously investigate and document every relevant details and publish their findings in a highly organized, easy to digest report, so that the prosecutors can understand and appreciate what the case is all about as they prepare for trial. However, in reality, the handoff between the investigators and the prosecutors is almost not that seamless. A lot of investigators do not even know how to prepare a good report that will demonstrate the investigative activities and their findings. The investigators and the prosecutors are interdependent, and the synergy between the two is what brings is about efficient criminal justice system. Therefore, where the investigation is weak, it will pose serious problems to an efficient administration of criminal justice. Investigation is one of the most important stages of any criminal trial process. Our court has always condemned both the prosecution and the investigator for shooting investigation and presentation of cases before the court. Our structural challenges affecting the administration of criminal justice system in Nigeria and the policing gap, delay in judicial processes, inadequate rehabilitation, reintegration mechanism, poor implementation of juvenile justice system, socio-economic inequalities, and structural failure. Weak implementation of the child and young person justice law, poor data management and case travel, weak application of non-custodial measures, and so on. Details and solutions of these challenges will be discussed at the penultimate chapter. Crimes that are rampant among Nigerians. Let me go. I give your attention, your rapt attention in this regard. I think it will be of benefit to identify and briefly discuss some offenses or crimes that are rampant among Nigerian youths. Mostly as offenders or victims of this are young persons, as follows: courtesy and violent crime. In Kwara State, it is prohibited to belong to or associate with secret societies, cults, and any other related activities. On the meaning or definitions of secret society or cult, see Section 14 of the Kwara State Secret Society and Cult Prohibition Law 2013, which provides, Section 14 provides those. In this law, unless the context of the rights of the past, secret society or cult includes any society, association, group, or group of persons, whether registered or not. This is very important, whether registered or not. Because sometimes you think you belong to a registered association and indirectly you are belonging to a member of secret society. Now, these are the factors of to be noted or to determine an association is a secret society or not. A, that uses secret signs, oath, rites, or symbols, and which is formed to promote a cause and the purpose, or part of the purpose of which is to foster the interest of its member and to help one another under any circumstance, without due regard for merit, fair play, or justice, to the detriment of the legitimate interests of those who are members. I will explain this later. B. Those activities are not known to the public at large, the name of whose members are kept secret, and whose meetings and other activities are held in secret. Pursuing activities which are illegal, inimical, destructive, or unlawful, or an organization not registered with their corporate state agency or institution as a club or society. The state here means Kwara State of Nigeria. Here we come. Any association that you belong to, even when it is a registered association, of course in which you have secret signs, secret symbols, or your activities are done in secrecy, is a secret cult. Or any association that you belong to, of course, on which you confer advantages on your member at the detriment of other law-abiding citizens, is a secret cult. Any association that you belong to, they are there too of animate or inanimate objects that are terrifying, is a secret society. Let me share a case with you. I prosecuted a case then before, I think it was before the issue, against the state. We have learned that the defendant belonged to members of a secret society. called Eye. This fact, all of us, we started the prosecution, and in the course of every the confessional statement of the suspect, and from a point, the defendant, the accused person, alleged that he was beaten. The accused person was a student of Kwara State Polytechnic. This is a dramatic scene in court. He alleged that he was beaten, and on our side, we said that the confessional statement was voluntary. Then the court ordered for trial to be tried. The defendant, during the course of giving his evidence in court, alleged that there are scars in his back. His lawyer said, "Show me not the scars in your back." The defendant removed his clothes and showed the court the back. Lo and behold, we all see the sign of the bed. The judge said, "That bed in your back is the one that will fly you to the prison." So as students, we need to be very careful. The type of symbols that you have on your body, the type of tattoo that you keep. If you have a tattoo of a bear on your body, and eventually on your way to Kanke, the police, in one way, they stop you, you go arrested even for another issues. One of the signs of belonging to a secret code is bearing tattoo that are terrifying or that suggest you to belong to that secret society. Someone alleged of the offense of belonging to a confraternity and really have the sign of evil at his back. He's corroborating my work and it's very easy. Eventually, because sentenced him to 10 years imprisonment. So we must be very careful. Section 7 of the law states the factors or circumstances through which a person can be considered or presumed. This is the danger in it. It's not even only about it can be presumed. There is a strong presumption. And the other one, once you are presumed to belong to a member and I can prove this presumption, if you lay your case on that of the prosecution and discharge my body as the prosecutor. So partisans can even be presumed. Now we must be very careful. Attendance of the meeting where all these activities are being done, maybe the ones are taken in secrecy. If you escort your friend to such an location and you are arrested and not with them, it is presumed that a member of secret code, even when your name is not on the register list. Your presence in that kind of society, on that kind of occasion, where they are initiating their code member, automatically confirm you members will belong to that secret code. Debate in a meeting or other activities of the secret society or court shall be presumed unless the contrary is proved to be a member of some secret society or court. Any person who has in his possession or custody or under his control and the signal, that's what I'm saying, or mark with any sign or symbol of a secret society or court, or undergoes any rites or takes an oath of the secret society or court shall be presumed to be a member of the secret society unless otherwise proved. It is notable, this is a very interesting case that was part of the prosecution too. That's the case of Calvin against the and it happened to the student of this institution. In Calvin against the this is what the court of appeal, JS, as the judge said. He said, in view of the menace of courtesy in our tertiary institution in recent times, which culminated in the anti-courtesy of Kwara State, the breach for which the convicts have been arrested, arraigned, and sentenced. The convicts ought to be sent back to the High Court to properly stand trial, and if tried and eventually convicted, sentenced to face the music so as to serve deterrent to others and their need. This is more so because two members of the religionists who, after purportedly renouncing their courtesy in their respective churches, have rejoined and revived their membership. They are reasonable persons who ought to know the danger of engaging in such unwholesome pastime instead of facing their studies, which is the paramount motive of coming to the University of the World. In this case, the two defendants before the court were court members, so to say. Later, I think it's one of the churches, so they went in and relegated their membership. They stated before everybody in the court that they are no longer court members and that they have renounced their membership of a civil society. But unfortunately, a semester after, they were arrested by the police in a place. Of course, at the point of initiation of some new students, I was part of the prosecution of this case. They were also sentenced to 10 years in prison and the court of appeal. So we need to be careful of our activities. Considering the foregoing, it may interest you to know that the punishment for the offense of courtesy are stated without. Now, one thing about the provision of civil and civil society law was first promulgated in Paris in 2006, and then the punishment for the offense was 10 years imprisonment plus 50,000 naira fine. Then in 2006. But later, ladies and gentlemen, the law was amended and it was whittled down to 3 years in prison. 5 minutes. Let me just quickly then, to the offense of kidnapping, I define the context of kidnapping, and the kidnapping stems from the terrorism act, which is an act who performs with the intention of furthering any ideology, whether political, religious, racial, ethnic, which involve causes or result in the kidnap of a person. Now, our whole law in Kwara State prohibits prohibited the offense of kidnapping is under Section 1 of the Kwara State provision of kidnapping law, and the punishment is under Section 15, which may be liable. Anybody that participates kidnapping of a fellow Kwara or any Nigerian or anybody generally, upon conviction, will be sentenced to life. Kidnapping is a serious offense of Kwara State. On the meaning of kidnapping or proof of kidnapping, the Supreme Court held as follows. It said when a person is detained unlawfully, the offense of kidnapping is established. The offense of kidnapping, contrary to Section 364 of the Criminal Code, was proved beyond reasonable doubt in the instant case. In the instant case, when the appellant and his co-accused person bonded and blindfolded the respondent and dumped her in the back seat of her car and drove away. So kidnapping is when you force anybody to confine anybody to a place against his will is kidnapping. And we should be careful even as students in a situation whereby you lock up your co-roommate in the room against his conscience is kidnapping. So we must be very careful about this law. This is a very serious law. Now, let me go to the offense of rape. This is one of the offenses that is in question. And this one, let me just discuss it without really going over. The offense of rape, when we were growing up, what we know as rape under Section 282 of the Penal Code is an unlawful carnal knowledge of a female by a male against her will, or someone that deceives her to believe that he is her husband. But the offense of rape of today are gone a bit different. In Kwara State, there are 3 different legislations that prohibit rape. As I said, the whole one that you know is that of Section 282 of the Penal Code. But with development recently, I think in 2006, we have another law, which is the Child Right Law. Section 31 of the Child Right Law also prohibits rape against a child. A child under a Child Right Law, as Amelia said, is someone not above the age of 16. There is a unique difference in the Child Right Law. These are the provisions of Section 282 of the Penal Code, which I will discuss with you. Now, the final one was the 2000. That's the violence against person law. I want to look at it. That was passed. This is very important. Yes, 2020. The violence against person law is a unique law, which makes it clearly different. You know, what we know before is that a man or a male cannot be raped, but that's not the violence against person law. Section 1 of the violence against person law define as unlawful penetration of the vagina, of the anus or mouth of any person against his will or without his consent, and what that consent is obtained by disease. You see, a comparative analysis of these three laws clearly shows that there are differences. As I said, the penal code is only a female that can be raped. Under the child rights law, a child, that's someone below the age of 16, when you have sexual intercourse with someone below the age of 16, is alleged to be raped. The uniqueness of the child rights law is that even with consent, this means that a child or someone below the age of 16, when he even said, "Sir, you can come and do it," you don't. She cannot give consent. The uniqueness or comparative analysis of section 282 of the penal code and the child rights law, section 31, is this again. The penal code made a provision that a man can marry a woman even if he or she, if she is below the age of 16, but with the signs of puberty. That is, a woman that grown all the physical features of a woman, a lady below the 16 that grow all the physical, a lady that is grown up. You know, there are some people that are so blessed, they are naturally endowed, that when you see them, they look big, they appear robust than their natural age. In penal code, it is allowed for a man to marry a woman below the age of 16 if she has all these features. But under the child rights law, he said no. Irrespective of her look, whether she has all these features or not, if she is below the age of 16, it is prohibited. Every man that marry and consummate marriage, you know, there are two things: marriage and consummation of the marriage. Any man that marry and consummate that marriage under the child rights law has committed rape for someone below the age of 16. It is now also clearly provided under the same child rights law that it prohibits marriage of a child. So if your daughter is below the age of 16, consent cannot be given. Such a lady can under no circumstance be married out. Now the uniqueness of the law is this: is that a student that is started is or are, that is whether a man or a woman, whether a female or a male, if you insert your finger into the mouth of another student, you are committed rape under the child violence against person law. This is very important. Even when you kiss another and you inserted your tongue into her mouth or his mouth without his consent, it's rape. If you use your pen and insert it into the mouth of another person without his consent, you are committed rape under the child rights. Under the violence against person law. And the uniqueness of this law is that it attracts 21 years imprisonment without option of fine. So it's a very strict law. It's a very strict law. I prosecuted a case before Justice Sempinawa, which I think I should share with you. It's also a security tip of a case of a student of Kwasu. The case I think is the state people of Kwara State against Yunusa and leadership. This is a case, of course, in which the security man attacked to the student hostel. The security man attacked to the student hostel was the defendant. The victim of the crime reported to school earlier a day earlier than others, and she went into this hostel. After she was in this hostel, she collected the key from the gate man and went into her room. But after arranging the room, she discovered that the water was not flowing in the toilet. She invited the gate man to come and look into it. The defendant looked into all these things and left at the middle of the night. The student discovered that the door was open. Someone opened the door from outside. And lo and behold, the gate man came and brought him his dagger and had unlawful sexual intercourse with this student. Luckily, the defendant was apprehended and was privileged to prosecute the defendant at the High Court, and he was sentenced to 21 years in prison without option of fine. What I want to draw attention to this is that you should be very careful, because in the course of evidence, we discovered that when the security man, the defendant, they came into our room to repair the tab. These people remove one of the spare keys. So when you are going through another room, in fact, when you are going through a student room, it's better, it's advisable that you change the key. If you don't have the power to change the key, make sure you put this lock. Just be away. Try and make some modification to the entrance. This is very key. And please take this note. Now, I also, in the course of the presentation, make another comparative analysis. This is the one I just said now, page 17. When I said a comparative analysis of these three distinct laws, prohibited sexual offenses shows their similarities and differences. A key provision of section 282 of the penal code shows that it is only a female that can be raped, whereas section 1 of the violence against person states that any person can be raped, whether a male or a female, can be victim of the offense of rape irrespective of their gender. Under the penal code, a female is said to be raped when there is penetration of a vagina by the male sexual organ. However, by virtue of section 1 of the violence against person, a male or female is said to be raped when there is penetration of his vagina or anus or mouth or any human parts or objects. The implication of this law is that a female student that inserted his hand or pen into the mouth of another male or female student without her consent has committed rape. Section 282 of the penal code, a man who marry or consummate marriage with his young bride below the age of 16 years cannot be charged to rape under the penal code once his wife is visibly of puberty age. Whereas a man cannot marry an underage below the age of 16 wife, notwithstanding that she is of puberty age or that the husband purportedly believes that the wife is above 16 years. See section 31, 3A of the Child Rights Law, Laws of Parenting. Finally, it is an offense for a man or a male student to date. This is also very important. It is an offense for a man or a male student to date or have sexual intercourse with a female student with or without her consent if she is below the age of 18. See section 31 of the Child Rights Law. Examination map. It's also another very interesting topic to discuss with you. Examination malpractice is a unique law in Nigeria because the facts and circumstances of where the examination was conducted, where the alleged malpractices were done, is a catalyst to determine whether it's an offense or it's a crime or not. As an undergraduate of the University of Ilorin, who was found cheating or dropping or impersonating another student in an examination conducted within the campus of the University of Ilorin, has committed a civil wrong. He has committed a law. He has committed a so-called offense against the handbook of the school. The implication is that if found guilty, is only allowed to face target and leave, but there is no jail time attached. But we should note that an undergraduate student that impersonates during NECO, WAEC, or JAMB has committed an offense triable under the Examination Malpractice Act, which attracts 3 years in prison or fine. So it is very important to know that a student, any examination conducted outside this campus, of course, which a student is found to be guilty or to have committed an offense or to have either impersonate or cheat during that exam, is liable to be sentenced to 3 years in prison. I cited the case of Raji Shade Pawakamitu against the Federal Republic of Nigeria. This is also another offense that I was privileged to prosecute. It is a very unique case that a student, after graduation from Federal Polytechnic, reported at the NYSC camp, and it was found that she was unable to write her name. She was unable to communicate in English language effectively. So she was taken to be a fake copper at the NYSC camp in Ipac, Kwara State. And she was handed over to the DSS. In the course of investigation, a shocking fact was discovered. She actually and indeed graduated from Federal Polytechnic. In fact, with upper credit from the school, then DSS commenced investigation, and investigation revealed that her husband is the lecturer at school. They called for her street and discovered the street as scanty, but highly marked, and we commenced prosecution of the case. But unfortunately, I won the case at the High Court, at the Federal High Court, but I lost at the Court of Appeal. It's been interesting to know that two issues were resolved. And this is the locus classicus when talk about examination malpractices in Nigeria. It was, once it was discovered, it was argued. Most of the opposing lawyers that were then, I was a very young counsel, I think it was in 2012 that we had this case. One of the lecturers, Dr. Kamadi, was also one of the counsel at the other side. Most of the counsel that I did the case with, I think about 5 of them are not senior advocates. Yes, I remember Bano was there. Many Bangoye essay, Biago essay, was there, Akakito essay. Most of them are lawyers on the other side. The issue to be solved against in this thing that the Court of Appeal are two. One, the Court of Appeal held that the offense of examination malpractice is a civil offense. It's a non-violence offense. And the Department of State Service are not investigated. So that was one. Then secondly, this is why this principle came about. That an examination malpractice done during examination conducted by the university or polytechnic or higher institution of learning is not a crime. Examination malpractice done in this examination are not crime, but rather they breaches the internal rules, they breaches the internal laws and regulations of the school, which the school has the power to determine. But to God be the glory, I later had the opportunity to distinguish between this offense in another one. In the case of Ebenezer Badavosi against the state, this is another unique case that done in the course of my prosecution. It happened that a senior advocate in Ilorin, Durabi NASA, was attacked on his way from office that matter to his house at Songo. And luckily he survived the attack, he was shot, and he recovered. After recovering from this attack, he went to court, he went to church and gave thanksgiving. He gave testimony of how he survived armed robbery attack and all this stuff. And that was how the project started. The second day, the project started receiving threats. He started receiving message that these people that the message was saying that we are the ones that we are coming for you and your 3 children. We kidnap all of you, except you pay a ransom of, I think, $1 million or so. The senior advocate was very, he was afraid. He took out his family and he left Nigeria. So, let me go show. Now, in the course of this, the senior, he came back, I think, some months, a year after. Immediately he came back, he attended the church service again. The prayer started again, he started receiving the threats again. When he has no choice than to cooperate with these people, and fact was sent for him to send money, and he sent money to them. Later, the DSS started the investigation. Eventually, a lady was arrested while he was about to get the money. Investigation of the lady led to the arrest of 2 other defendants, and the trial started at the airport before the former chief Justice Gosilo Otawa. We were able to prove our case. Now the trial court, in its magnanimity, convicted and sentenced the defendant for the offense of extortion, and they were given just a year imprisonment or payment of 100,000 naira fine. They appealed to the Court of Appeal on the grounds that the DSS cannot investigate the alleged offense. I was able to distinguish between the case of Salita Akalitu against Federal Republic of Nigeria and Ebenezer Badavosi, and the Court of Appeal in this case agreed with me that the DSS can investigate the alleged offense. They now saw the unique part of this appeal is that they now substitute the offense, the sentence of 1 year imprisonment with 20 years imprisonment for the defendant. So it's another unique prosecution that I can never forget in my life, and it's so. Now, in rounding up, I also mention mention of other offenses that are rampant among the Nigerians, which I listed there, to include cybercrime. The time will not permit me, but I want to state some of these practical offenses. There's also a case that happened within this campus and Tanke of a case of a young girl who refused the advances of a boy, a student of the faculty of Agriculture in this school. And the lady having refused the advances of this boy, they traced the lady to her house, and on the fateful day, these boys came to the lady's house. She was stabbed, she was raped to death. I also have the privilege to be part of the team, and in court, I'm happy with this. I'm proud to say that the sentenced to death. In rounding up these cases, I'm trying to address some of the challenges of administration of criminal justice. If you go to page 18 of the presentation, I did mention of some things as solution. Firstly, is on the issue of strengthening the law enforcement. One of the challenges of administration of criminal justice in Nigeria, particularly in Kwara State, is that if a officer that investigates an offense attacked before we start the prosecution, we will have to transfer to Nigeria, and it will be most difficult in getting this type of witnesses. I think our police, Nigeria police, also our police structure should be restructured. The police must need to be restructured in such a way that the state, all the people, we have the say in police. It's not about reporting of the crime. The best way is you can fashion our police hierarchy in the way of which upon the act of the judiciary. The police officer, maybe below the rank of inspector or below the rank of chief superintendent of police, their recruitment, discipline, and control should be under a body that is known as the State Police Council. With this, if people in the state are given the power in discipline of the police, they will be more accountable to the people. This is one of my suggestions. Then in the judicial reform and also anti-corruption measures, I will mention of Nigeria, we are still learning how to fraud while the world is moving fast. As long as our judges are writing a long hand, and they increase my Lord and so we continue to write. If we talk for a few minutes, the judge will write for, when we talk for 2 minutes, the judge will write for 20 minutes. And these are part of the factors that are bringing about, the delay in the administration of criminal justice. Also, before you know it, the judge will bring time, because judges in Nigeria take distinction from both the council and the litigants. And this has slowed down the administration of criminal justice in Nigeria and in Kwara State in particular. Also, the anti-corruption measures, I clearly stated it. You see, before the Yoruba says, anything in life that takes your time must worth it. A work that will take your time, will take your energy, must be able to sustain your means of livelihood. So as long as judicial officers, particularly of lower bench, state council, and other public officers in the application of criminal justice, as long as they are poorly paid, it will be very hard to fight corruption. Corruption can only be fought, or can only be fought. Corruption can only be fought and it can only be reduced. It's not as a matter of principle, but when you are one, contentedness, and two is when you have a lawful means of livelihood. So we cannot fight corruption and say that the public servant should be paid with peanuts. It's also not an essential, even in this citadel of knowledge. You want a lecturer to be corrupt. You want a lecturer not to take anything from the student, but the lecturers are poorly paid. How possible? One other factor that I consider is expansion of non-custodial center and restorative justice measures. If you look at our laws in Nigeria, most of our penal laws, all you see is just punishment, imprisonment. Then we should look and bring our law in such a way that the punishment can even be community service. Most of our law provide for this, but how long do we activate this provision of the law? So we should not just look at the law and make it in such a way that all the time, whoever wrongs or against the law should go to prison. There are many people in the prison that are doing nothing. They will just sit and be having free meal. So I think our law, we should activate the provision of the law that call for community service, or probably when someone alleged of committing a wrong should be given punishment time to go into the bush, clear the bush, sweep market, and do some other things which are community and beneficial to the people, rather than just sending people to prison. Then another one, the restorative part is that from my experience as a prosecutor, I have discovered that whenever you see an ex-convict that commit another offense, if you ask him why, his answer will be that when he came out of the prison, his family will reject him, his friends will no longer associate with him, the community will look down on him. However, if you go to under the bridge, on the other hand, they will hail him and like you. He has shown and he has come. They will welcome him. So they find it more peaceful. They find it more interesting to go back to their cohorts, to go back to their core criminals on the underworld. So Nigeria, we should, I think we need a reorientation and always give people a second chance. For the fact that someone has come out of prison doesn't need the help of life. We should welcome them and give them another chance. Like, so this, once we do this crime rate. Thank you. Then I also made mention of rehabilitation and integration, the full implementation of legal framework, as I've said that the ACJ, the child right, the other laws that we have. What we only activate out of this law are the sections that have to do with trial, the sections that have to do with punishment, the legal technicalities. What the fantastic provision of the law, which have to do with, like, for example, the offense of rape, do not provide for sexual offense rehabilitation center. Most of states don't have this. You know, we talk about the life kits. We, of course, we victim of rape ought to be given. You know, also we talk about the correctional center. Now our prison just came from Nigerian Prison Service to Nigerian Correctional Service. But the question for you and I to answer is that our prisons, our Nigerian prison truly correctional? That's this thing. Well, finally, I thank the organizers for the opportunity of coming to this panel to present stuff. Thank you, sir. There is a quotation that I noted. Please, can we have our seat? As a student, when I was in this school, since that time he's still here. When we talk about university students, I've always campaigned I was full of pride to be an undergraduate and a university student. Because it's not easy to be in the university, particularly when you're a law student. And what always comes to my mind is the victim of my Lord, Honorable Justice Okuta of blessed memory. In this second or the case of Ogalba in this University of Maiduguri, that as youth, you have the whole world before you. As a university student, you have now, in my 20s at the bar, and there are some of my dreams that are not even actualized. You have the opportunity to start to write and even go far. The quotation of his Lordship going he said, ours is not a perfect society, but our imperfection can be eradicated by our observance of the rule of law. Human resources are our greatest asset. A university student is a priceless asset. He is on the threshold of the useful service to the nation, and we cannot avoid to stigmatize him of commission of our offense and take it as an independent. I thank you. Thank you all.
You gotta stay indoors. Right now, it's more long. Whether you like or not, jump my shit, make a relay. We should be more gone. You left me more strong. I don't feel that I'm God. And if you that all I want is your.
Thank you so much, sir. We are honored to have you here, and you must say I'm mesmerized with the eloquence and knowledge of God. Thank you so much once again. Looking at this, it's an indisputable fact at this point that we need others for you. Like faculty of the University of Ilorin leads other faculty, they follow. Piano Baffa once again. So, well, I will call on one of our persons over here, the person of Farouk Alibayo. So now we're moving to the game session and we'd like to anchor this session in himself. So, Farouk Alibayo, please. So, this is Farouk Alibayo, SA Lieutenant Boutique of the Union.
I'm very sure a lot of people will be surprised that I want to anchor the game section. Yes, I also play. Yes, I also play, and as a matter of fact, the honorary will share something in common. She's wearing Alibayo, I'm also Alibayo. Once again, I am Alibayo Farouk Alibayo. She's from Oyo State, I'm also from Oyo State. So if I don't want to play, I should play. So, I'm the developer of the game. That's another surprise thing for me. So I developed the game, and I left it Toyo's art pursuit. The Toyos is from her name, Oma Toyos. So, I need 2 to 3 volunteers to play the game. I will serve as a memo for you. I will play the game, and then the other people will also play. And I'm very sure if you can finish all the 3 stages, LSS has something for you. But I'm very sure. Okay, let's see. So this is the first game. We've scattered the name of our island. We've scattered the image of our mothers. You will not be angry with us. So we now look for people that will fix it up for us. So I will start the game now. Okay. So we now okay, let me see the volunteers. We need 3 volunteers to play the game. 3 volunteers. Hey, I'm getting. We need 2 more people. All to come by level.
I choose that law students go beyond the classroom. We don't read laws alone. We are actually taking enthusiasts and we have something with us in. Round of applause for law students, please. Thank you so much. Well, now moving on to the next and very important item on the other events. I'd like to call on our father, our beloved and distinguished king, to hand me this piece. I feel I'm still young and I don't think I can do that. So we will proceed to the launching of the magazine, Legacy of Light magazine, and I'd like to call on the dean, person of Professor Bashir. So a round of applause.
our guest speaker, I want to, on behalf of the faculty, appreciate you once again for finding time to be here and for bringing us to the topic. But this is your faculty, and you are no stranger here. Well, while I am not jealous of what I'm about to do, I just want to remind the DPP that we had a discussion. We had a discussion on the Council of LSS. He's wearing several caps. Past president, he also belongs to a particular sect. Someone to come and deliver lecture, they propose to add a brand envelope. But I know that my brother will not take that envelope. Rather, he's going to spend money here today. I know he's a civil servant, so he may not make his announcement. But what delights me most is that we've had personality lectures, but this lecture is a lecture with a bag. It's a lecture with a difference. No personality lecture is going to has done what I'm about to do now. There's a magazine here, and I want to, every one of you that I'm going to call, to please give your support to these students. You know, some of my students had issues. I brought them to the office. So I was asking them questions, and I found out what was not in operation. What is our own business? Come to school, read your book, your parents will send you money. But I found out that every student seated here have one thing or the other doing apart from academic, fetching them money. Please clap yourselves. Online lecture, online this, online that. So, without wasting much of our time, it's almost 3 o'clock. I want to thank you all for standing with us up until this moment. I want to request the organizers, LSS, that Professor Ilorin will help you link up with our father, our grandfather, Professor Malam Skololwani. I am sure you didn't reach out to Oga. I am very sure of that. I know students, while I want to encourage you, I wouldn't want to scold you much, because if you had brought this thing to my attention earlier, I would ask you where to move to. But I know you won't regret what you have done. We have to support you and encourage you. When we're a student like you, we also make mistakes, and our guys correct us. For this purpose, I am in touch with representative of KKLA saying, do you want to talk or I should talk? I should talk. I've been assured that KKLA will reach out to you on this magazine. Maybe I should show you. If you go home without a copy, you won't enjoy this. Too bad the lecture is not complete. This is my sister on the face of the magazine. All for her today. All for her today.